Hello, fellow seekers. I hope everyone is doing well. It's only been about a week, but I feel like it's been a month. Oh my goodness. I'll try to make this very brief as to why I have been absent, and then we'll get on with this, which we have been waiting for, but now it's just kind of making me sick. Anyhow, very quickly, Hurricane Milton. Number one, we are okay. We had, limbs fall down, all that kind of stuff, but very, very blessed when I look at the people from Hurricane. I'm sorry, somebody just knocked on our door. This is just true life right here. Must have been Amazon. I heard a knock and then somebody ran. Anyhow, so of course, Helene, which devastated all up and down the coast. And I know people in North Carolina, Asheville, mountain roads washed away. They didn't expect all this. I know some people who live in Asheville and they haven't had power all this time, and they just got it back on the other day, but they still don't have water. I just have to say that for a minute because I do want to think about all of those people, because we are so blessed, those of us who did fine. And excuse me, and big shout out to the linemen. I mean, we had people come from multiple states to help us out, and they worked so hard, and I know people would be impatient, and that was my problem. We were without power for a little while. Not that bad, though, because the air was actually cooler out there. The storm made the weather cooler, so it was very bearable. We had backup battery fans, and we just kind of ate our junk food because there really wasn't anything to eat, but neither here nor there. We are great, but the biggest problem is we had lost power. We lost power for several days. Let's see, we actually got it back Sunday. The storm started, Wednesday night, Thursday morning last week, and so we were very lucky to get our power back on. But then I had, many people had problems getting cell phone service. We had problems with internet. I've still been continuing to have issues, so we'll just see how this all goes. But I have been keeping up with this Sarah Boone trial. I've been watching it faithfully, even though haven't really been able to. I wanted to share so much with you all, but I'm sure you've already seen it. I'm just going to shout out, excuse me, to my favorite people I've been watching. Joel from Surviving the Survivor has been giving some great reports from inside the courtroom, and he's been able to observe Sarah, and he's made some wonderful observations of her. Emily D. Baker has just started. She just started doing her lives. I think it's the past 2 days, and I think she'll be on live as well. And I've been watching. I just want to shout out these people that I watch who I really like. Reporting live from my sofa. And I always love to watch Dr. Barry because she gives her insight on the whole thing. And so, yeah, there's so much. And it's made me nuts because there's been so much drama in the courtroom. But you know what? The way I look at it is, we can always go back over all that other stuff that went on, because that is crazy. I was just like, what? And so much more has come out with Sarah. I'm sure you all know. And just to let you know that I really have been following it, because even though I am a one-woman show and very limited on, I am not tech savvy, but I'm hoping to improve that and make things easier for me and you all. Just so you know, I've been watching. Here are some of the things that you all will probably identify with. 5 peppermints, 2 juice packs, 2 bags of chips, a bag of candy, and either a Pop-Tort or a Pop Fart, Pop-Tart or bag of cookies. That was Sarah's request, that James Owens, bless his heart, asked the judge to get for Sarah from the commissary, because bless her heart, she has to get up at 2 a.m. Now, setting aside that it's Sarah, if it was just somebody that we like, that's a long time. She gets up at like 2 a.m. in the morning. And then, of course, then court's from like 9, and then she doesn't get back to her place till 9. So the commissary is closed. So he requested those items to the judge, Judge Cranick. They were denied, just so you know. Y'all probably know this. I'm sure many people have been covering it, which is great. But I just think there is no end to Sarah. I just get more and more triggered about her, and I am just, and I'm just going to be a few minutes late starting from the live, but I think I heard from somebody that I was watching that George's family is there, because I know we are here to look at Sarah and just pray that she gets life. I'm sorry. No, I'm not sorry. I don't know why I always say I'm sorry. I am not sorry. There's so much more that has come out that is just horrific. And I'll tell you what, make no mistake. Oh, before I say anything else, if you are new here, welcome. I hope you find this a warm and welcoming place. I'm very laid back, not real professional. I mean, I try to be, but you know, I'm just here. So I'm not a lawyer, a paralegal, a psychologist, a psychiatrist. I am just somebody who is just recently, over the last couple of years, become like addicted to true crime. And, you know, especially people like Sarah Boone, Daryl Brooks, and many other people. And I'm just like, how, what, why, what is going on in their brains? And I think I just want to try to understand, but I don't think people like us can understand somebody like her or Daryl or many other people. But the biggest thing is we get all into the courtroom drama and Sarah and the attorneys, and it is quite a, look, it's been a shit show, guys. I'm just telling you, if you've been watching it. The jury selection thing, all that kind of stuff. But at the end of the day, I just think of George and what he suffered through. And the more I see her, the more I dislike her. And I just think, oh my gosh. And again, these are just my opinions, my thoughts. I probably would not be a good juror. That's why I'm here, like, because then I can just say, I don't like her. You know, I don't like her. But what George went through, and the more I see and hear, I really think that she was more of the abuser than George. And I'm going to say, make no mistake, I mean, Lord, these people, what did Judge Cranick say? You know, because I can't think of anyone's name, Mr. Owens there, you know, he's going, well, you know, we only had so-and-so days, and Judge Cranick says, well, you know, y'all did parachute in here. You knew what you were signing up for. This is one thing I truly believe. I do believe that way from the beginning, and even when the state offered her that oh my gosh, wonderful deal, that she foolishly refused because she would rather, you know, risk going to prison for the rest of her life and think that she's right about everything, which is, that's a shame. But I really think Mr. Owens' intent was to get that plea deal for her. And she said, not no, but hell no. And the way I've seen everything going, I really do think, my opinion, that she is running the show, or at least trying to. Because all of these ridiculous requests, you know, Patricia Cashman would have said, are you out of your mind, woman? I'm not going to ask for Pop-Tarts for you, you know. And the judge did deny it, because you got to realize that the courthouse, I learned this from Daryl and his trial. He wants certain things, but the jail has their own set of rules too. So the court has to be careful not to, get into their territory. So there's certain rules and regulations and all that. So they said no, because they sent her 2 bag lunches and they have a bag of cookies in them. Now some people were saying I get it that she wants the snacks and all that kind of stuff, but I just feel like she's acting like she is going to a Hollywood premiere. Ugh, I can't even look at the back of her. And just because of these requests. And there was something James Owens said yesterday. Like I said, the best way I'm going to deal with this is I'll probably go back, like I said with Daryl, and play all of those moments, because I did keep up with the hearings and everything. And oh my gosh, they were throwing, the attorneys were throwing shade at one another. We'll just have Sarah be the gift that keeps on giving, like we did with Daryl, if you all would like. Because oh my gosh, there were so many things I wanted to talk to you all about. And I do know that the jury, they ended up picking 6, because here in the wacky state of Florida, we do things a little different from most people. Hopefully they'll get it right here. But there's 6 jurors for second degree M. They only have the 12 jurors when it's first degree M. So I know Joel had described the jurors. My numbers are off a little bit, but at the end of the day, there were 6 chosen and 8 alternates. But I don't think anyone knows who's the alternate or who's going to be the real juror. And that would make sense to me. I say the real, I mean, they're all jurors, but the ones who really get to decide. Because if they found out they were alternate, they may not put enough time and energy into it. And so the way Joe had said it, there were, out of the 14, there were 8 women, Caucasian. He said the ages were between 30 and 55. 6 men. Now, I might have heard him wrong, but he said 2 African American and 3 white, ages between 30 and 60. But it comes off a little short, so I don't know what the last one was, because that comes up with 13, but that's kind of the gist of it. He said they all look very serious, so hopefully, I just hope nobody's in there. You always worry, like you hear these things about the jury and that somebody in there and they didn't tell the truth and it messes this up and Sarah will go free. That would just make me nuts. The other thing I know was just a little side thing, but I just wanted to say that I know most of us know who are really paying attention, who have followed Sarah and all of her crazy circus antics. But yes, she's on attorney number 9. She's had 8, but I see a lot of people getting it wrong and saying, well, she fired all of her attorneys, and we all know that's not true. 4 of them were conflicts of interest and other things. I think a couple of, one I know had represented George, and I think another one had represented maybe a witness that was going to be for George or Sarah. I forget what it was. But there were conflicts of interest. The other 4, yeah, they had it. And I wonder if they're all sitting there watching. So really, there was only 4 that Sarah messed up. That's still kind of bad. And the other interesting thing is, because I was wanting to see how long Judge Cranick had been judge, because we know that she had Judge Wooten, and now I'm trying to find my notes. Okay, here we go. Because I was looking through it. So it starts off, and I don't know if I ever saw any hearings with this judge, but as of July 14th, 2020, there was a Julie H. O'Kane, I think it is, who was actually the first judge presiding over this case. Okay, and then Wayne C. Wooten, who many of us have seen her with, came in on February 23rd of 2021. So really, Judge Wooten has been with her most of the time. And then Michael S. Cranick, Judge Cranick, whom I just think has endless patience. But I mean, I'm starting to see him wear thin, rightfully so. But he still remains so centered, which I love. It looks like he came on the scene around January 16th of last year of 2024. So he's not been with Sarah for quite a year. I just thought that was interesting to note. So really, Wayne Wooten was with her most of the time. But now we have Judge Cranick, and I think he's been very fair. What was the other thing I was going to say? You know what? That's enough. Like I said, there has been so much drama. And yesterday, if y'all watched that, that was nuts. And I can't wait to go over that with you all. But let's go ahead and see. They're bringing her in. Oh, the other thing I want to... Oh, she has on some pink, and I can't get over it, but she's had pink handcuffs. Sorry, from the get-go. Let me see here. Yeah, pink handcuffs. Okay, Joel from Surviving the Survivor. Sorry, it's a mouthful. He was saying... I'm going to stop this for just a second. There we go. He was saying, and I thought this is very interesting to note with Sarah, is that he said she could not, because he said he was only about 10 feet away from her. He said she could not be still. She was either taking notes, which we know she takes copious notes. But the attorney, is it Mr. Henderson, the gentleman who got up and he seemed very confused. I feel bad for them because I know you feel bad for them, but then they chose it and then now you're stuck. I think it was Mr. Henderson. He said she was yapping in his ear the whole time, just yap, yap. I don't think she was doing anything that like made her look too horrible, but he said she was talking nonstop to him. So that's probably why he didn't know what was going on, because he had to listen to Sarah yap in his ear. And she was taking notes. And the other thing that I noticed is that I'm telling you, she is running this show, but she looked, yesterday was the first day I saw her look mad because there were many things that did not go her way. Man, you saw that smirk smug of hers turn into a, but anyhow, I saw her touching, like she was like part of the team. She was touching Mr. Owen's laptop and scrolling through it and looking through all the papers. And I heard many different attorneys say they had not seen anybody involved like that. The only one I can say that, and I haven't seen a lot, trust me, but the Hannah Payne trial, she was very involved. She almost acted like, because she only had the one attorney who was, that's a whole other story if you didn't watch that case. I have a whole playlist, though, of her trial. But she was very involved. And, I mean, Sarah, and I'm just saying all of these weird requests because they wanted all of these witnesses in that now, and then all of this. She wanted, like, all of George's medical documents released, all of hers. And then finally, Mr. J, who is, like, the king of shade. I mean, he can be off-putting, but I don't know. In this case, I love it because it's like, they've been working on this for years. And it's like, enough of these shenanigans. He's just so over it. But they were like, and I know these are things that Sarah wanted, because if they sound weird, Sarah wants it. So I think he's going to say, Mr. Owens is going to do what Sarah wants. At the end of the day, though, I think she's going to get mad because she was not happy yesterday. But, okay, there we go. I lost my train of thought. Oh, well. Anyhow, I know what it was. There were all these medical records from the jail, and the way Mr. J said it, I mean, you could tell when he was throwing shade, man, I bet she was one to... But he said like maybe 5% of it would come in, but a lot of it is just talking about, well, when she first checked into the jail, that she was anxious. She did not want to be alone. She wanted to be with other people. That explains maybe why she didn't choose the when they gave her the deal when she was pro se she could go to a cell by herself. She doesn't want to be alone. She has anxiety. But there were other things that came out too that she admitted to having an alcohol problem, and that she could, something about like she could be violent when she's angry or something like that. Something to that effect. But I'm thinking, why didn't Mr. J go on and use that part? But maybe he might already have everything that he needs. But then the way he was saying, he goes, and like the rest of it was just going to be things that were not relevant and embarrassing. And I thought, oh boy. And I'm like thinking, no, put them in because we want to find out. Anyhow, so there's that. And I was just trying to give you a few things to lead up to it. But okay, I'm going to shut up now. And just like watch Sarah, though, you can definitely see when she's happy and when she's not happy. And how having her hands all over oh my God. Yeah, she's running the show. Oh my gosh. Oh gosh, just remember, guys, please, we've got to pray that George and his family get the justice they have waited for so long and richly deserve. Yeah, see, people are going to report about the law, which I can't really do, but I like more like observing people. Oh my goodness. Yep. No Pop-Tart for Sarah. She just has water. And I notice it looks like she has a little bit of like foundation and maybe some eyeliner or something. I don't know how she scored that stuff. One thing Joel said from Surviving the Survivor, he is so hilarious. He said, I don't want to be insensitive. I guess she must have had a skirt on. Was it yesterday? I don't know, the day before. He says, but you can tell her legs have not seen sunlight.
Bless you.
In 4 years. Because he said her legs were so white, it was blinding him like the sun. Oh, look at her. See, she has to have all these people around her. She loves this. That's the man. Poor Mr. Henderson. Let's see if we can see her whispering. Maybe she might not be so... Look at her. See, look at her. She has to have so much control of everything.
I'm ready when you are.
Sure, on behalf of the state.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone. Kevin Beck, Sarah Boone.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them was just billings, observations by the medical personnel, so don't necessarily apply to the issue of anxiety, as the court indicated. I did include certain pages that discuss depression issues, because I believe that they were related to anxiety. And I've identified 4 or 5 other pages that are
Oh, okay, that gentleman there. It's very hard to hear because
Of those 119 images, how many are being sought? 15? Okay, thank you.
Oh, they did tear it
State
down.
response.
Apparently, these are all just related to January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
Oh,
You
this
speak
is,
of the 81 pages?
Yes, sir.
Thank you.
so this
Nor
is before the
new
crime.
119 pictures that still not in a PDF form. So
Okay, I got to say that. Stop that. So they, and I get it. Okay, I'm just going to say that I know that the defense has not had time, but they did parachute in, like Judge Kranick said. And what they did is sent, I think this is Sarah's records, 119 individual JPEG images instead of just putting it all into one file. And you can tell that Mr. J is like, he is like a perfectionist. And he said some of them were upside down, sideways. I mean, that is so Sarah Boone-ish. So that, if he looks put out, I don't blame him. He is so done.
of the 15 pages, the first two that they list are pages 9 and 10 out of 111, and I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp, so I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those two pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the tox screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed that's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object. nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63.
Excuse me, guys.
It appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was.
Oh, Lord.
One of my trips down here, I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office.
Here's your problem.
For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to
We're throwing
the state.
Shelby under the bus now.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Whatever.
My understanding, that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from
Sir, step up to a mic.
building department, subcontractor, the request was made on 27th. I suspect they waited until they received confirmation payment, $135 for receipt of the
And that gentleman speaking, he's what, like you call the third chair attorney. Of course, Mr. Owens.
Any
is the
further argument
first.
or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing.
And of course, we couldn't hear what the man said, but
Is that the 119 pages, sir?
No, sir. It's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
I can't believe you did it.
I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So, for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies. And the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide.
Okay.
This is
I
a problem.
appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state. We had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with
Why don't
regard
you
to the
have it with you
Richardson
now?
issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Oh boy.
Judge, defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to
We'll never get that.
put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events.
Get up to the microphone, man.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did.
Oh boy.
On the justifiable use of non-deadly force.
That does not answer my question.
Yeah, he's been not good about answering. I love how Judge Crane gets to the point.
Okay.
I'm interested in using.
Would you get to somewhere where we can hear you?
Standard instruction. It is up to you to decide what evidence is reliable. Use your common sense to decide which is the best evidence and which evidence should not be relied upon in considering the verdict. Will you read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is neither possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards at opening
You're here
statements.
now,
I don't
man.
know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
This is an excerpt from.
This is so embarrassing. I mean, could this go to appellate court for ineffective counsel? Oh my gosh. Let's hope not. I don't know the law, so. But man, Judge Crane does.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Oh boy, is Madam Clerk is everybody going to want to quit after this? Like I said, I don't want to be disrespectful to Mr. Owens because, I mean, he did come at the last minute and he is fighting vehemently for for Ms. Boone. But this whole thing, I mean, it is like, they're exhausting. And I think Sarah thrives on chaos. And she's probably, as an effect, her chaotic energy has filtered in to all of these people. Good Lord. You all probably also heard there is more to this thing when Sarah was interviewed by the latest medical or psychologist or whatever, that, you know, at first it was just like she hit his fingers with a bat, and then she hit his hand with a bat, and allegedly, according to what she said, she also beat the crap out of him with the bat, which supposedly lines up to the injuries he had on his head. So in addition to allowing him to suffocate, she pummeled him with a bat. And I think she even said she shook the suitcase in anger, because now it's going to be self-defense, although everything screams in that 2-hour interrogation of the detectives that it was a good day. Nobody laid a hand on another. And she wants to make George to look like the raging alcoholic. And that's just not fair. Look at her. She just thinks, she thinks she's an attorney. She's probably going to have Mr. Owens ask if she can have a briefcase and a Starbucks mug. and not at all a bit of no sadness, no remorse, nothing. He's just like a forgotten piece of garbage. Makes me ill.